Michigan versus Lawrence Buckner, 21S00203.
Charlotte Lundberg on behalf of the people.
Andrew Banis with it on behalf of Mr. Buckner. Your Honor, I'm sorry I wasn't able to reach Mr. Buckner at the contact information I have for him, but he is here today. Mr. Buckner, can you hear me?
Mm-hmm.
Okay, good. Thank you, sir. My notes show that we had a bench trial on June 29th and he was not present, so I don't know why. Mr. Buckner, do you know why you weren't in court on June 29th?
Yeah, I had problems with my Wi-Fi at my house. I called the court, but I was actually trying to get in the meeting, and all my stuff was messed up. It was storming. Everything was messed up around my house. Cell phone, everything. I was on the phone with the court, but it is,
Well, Mr. Buckner, that was a day and time that was scheduled for trial. I hear you say you were on the phone with the court. The court didn't receive a message from anybody in the clerk's office that day.
Yeah, I called because I actually got in an argument with one of the people on the phone. That's how I know they're going to remember me.
Today, we're diving into the chaotic courtroom of Michigan versus Lawrence Buckner. Case number 21S00203. Right from the start, you can feel the tension. Mr. Buckner is present, but clearly communication issues and technology problems are already creating a storm. His attorney, Andrew Banis, and the court are trying to get to the bottom of why he missed the previous bench trial. Buckner's Wi-Fi issues, stormy weather, and arguments over phone calls set the stage for a showdown full of drama, contradictions, and defendant who thinks firing his lawyer is the smart move. Stick around. Things only get wilder.
You were difficult that day.
Yes, ma'am. I was being very difficult because I was trying to get to you. So they will remember me. They will definitely remember me, ma'am.
That's the thing. You're always honest, Mr. Buckner. All right. Mr. Banis and Ms. Willenbring, do we want to schedule another non-jury trial date?
Yes, Your Honor. And Mr. Buckner, just so you know, I don't know if you can see the chat, but I guess the phone number I have for you is not good, but I put my cell phone and my email in the chat.
Whatever. My number is good. I never received one phone call from you. I called the court. I called the courthouse. So, and you evidently you didn't get the message, and my phone records show that I didn't receive.
Now, watch closely here. Buckner admits he was being difficult on the phone, and he even acknowledges arguing with the court staff. This is classic pro-SE panic. He's taking responsibility in one breath, then complaining in the next. The tension is real, but what's fascinating is how his behavior undermines his own defense. Courtroom etiquette is not just rules on paper. It's how you protect yourself. By creating conflict instead of cooperation, he's stacking the odds against himself. For viewers, ever wondered how one misstep like this can escalate a trial? This is exactly it.
The text message, nothing.
Mr. Buckner.
I haven't even heard from you. I haven't heard from you since the last time we talked. You have not even attempted to contact me in any way, form, or fashion. So, I'm not going to sit up and allow you to do this to me,
sir. You're my client. I work for you. I don't work for the court or anyone else. I can show you all the dates I've tried to.
Listen, man. I called the court too. Stop.
Everybody stop.
No, we ain't gonna do this.
Please, Mr. Buckner.
Yes, ma'am. All right, Miss. This my case is supposed to be dismissed.
Mr. Buckner, I'm gonna ask you one more time.
Okay. Yeah. All right. I want to fire him. I don't want him no more. I want to fire him. Okay. He ain't try to talk to me. He ain't contact me.
Here's a pivotal moment. Mr. Buckner's attorney is muted by the judge because Buckner won't follow instructions. This is not just drama for the cameras. It's a serious legal issue. Disobeying a judge can lead to contempt of court, adding penalties on top of existing charges. Notice how the judge stays professional, calm, and laser-focused, while Buckner flails verbally. This contrast is what separates courtroom authority from emotional chaos. Audience, think about it. If you were in his shoes, would you argue every point, or would you trust your attorney and focus on your case?
I'll just say one thing.
1 second, please.
Yes, ma'am.
The record should reflect that I've muted Mr. Buckner because he would not follow the court's instructions to stop talking. So he has been muted. Mr. Buckner, I'm gonna advise you very clearly that you need to follow my instructions. If I say stop talking, that means stop talking. Otherwise, I'm sorry, but you may have to be held in contempt of court. Contempt of court is an additional penalty on top of anything else. So please stop talking when I ask you to. It is not appropriate for this type of argument to occur on the record. You're muted, so I can't hear what you're saying. If you want to talk to me, you need to first acknowledge that you will stop talking when I ask you to. And so you can do that by nodding. Is that a yes?
And just like that, Buckner fires his court-appointed attorney without understanding the consequences. Here's the lesson. Court-appointed lawyers are not optional luxuries. They're there to ensure defendants receive a fair trial. Buckner's refusal to communicate, combined with unrealistic expectations, turns solution into a bigger problem. The judge explains patiently that he can hire his own lawyer, but until then, he's stuck. This moment highlights the gap between emotion-driven decisions and legal reality. Viewers, ask yourself, how often do people sabotage themselves simply by not listening carefully to expert guidance?
Well, so first of all, Mr. Buckner,
He's fired.
you're still talking. Do you want to be held in contempt?
No, I don't want to be held in contempt. I just want him not to be my lawyer no more.
I heard what you said, so you need to stop talking like I asked you. So first of all, Mr. Buckner, he's court appointed. If you want to have a different attorney, then what you can do is you can hire your own attorney. This is a court appointed attorney. You don't get to choose who your court appointed attorney is.
Well,
Stop. I'm still talking. Please don't interrupt me. You haven't even had an opportunity to try to establish a relationship with Mr. Bannis. And secondly, Mr. Bannis does not work for the court, so you can't call the court and expect to speak to Mr. Bannis. Mr. Bannis works for the public defender's office. You have to call the public defender's office. Now, what would you like to say?
This is what I would like to say. That lying individual ain't trying to contact me. I have a cell phone that works every day. Okay, so he has not contacted me once.
Buckner claims he never received any communication from his attorney, but the court points out he never tried to contact him either. This is the perfect example of a self-inflicted legal trap, blaming others for your inaction. In real-world terms, this is like saying your GPS failed, but you never tried typing an address yourself. The drama here isn't just courtroom entertainment. It's a lesson in accountability. And notice how the judge keeps redirecting him calmly, making it clear that freedom depends on effort and cooperation. Audience, comment below. Do you think Buckner is being unreasonable, or is the system at fault?
I ain't seen no type of, not even a physical notification. So if you couldn't get in touch with my phone, no letter, nothing, email, has an email, everything. So there's no email or nothing. Okay, but then I get this third degree about, or some type of communication with somebody who has not tried to establish something with me. So make it make sense, Ms. Washington.
Mr. Buckner, first of all, you two haven't talked, is what I said. So the bottom line is, you don't know whether or not he has the correct phone number for you or not. You didn't even allow that conversation to occur.
You know, he never cared to ask about nothing.
You haven't had a chance to go into a room. If he doesn't have your number, how can he ask you about anything? He's trying to give you the communication to get in contact with him.
He's trying to give me the communication at the last moment. And you sit up here chastising me. And he ain't even trying to contact me.
You're talking over me again.
You asked me a question. No, I
didn't. Now, you already answered that, and I'm telling you some other additional information, and I'm not going to continue to argue with you.
It's not an argument. I'm not arguing with you, man. You know, I just don't feel comfortable with this man representing me. I don't at all. I really don't. You know, I don't know what else to tell you.
Mr. Buckner?
Huh?
Do you want to hire your own attorney?
How can I hire my own attorney when he already in violation of ineffective assistance counsel? He's already in.
Now, watch the emotional intensity peak. Buckner continues interrupting, complaining, and casting judgment on his attorney, calling him lying and ineffective. Meanwhile, the judge breaks it down logically. You haven't even established a connection, so how can you judge effectiveness? This is classic courtroom tension, emotion versus procedure. It's both frustrating and entertaining. Viewers, notice the irony. Buckner's loud complaints make him look less credible, not more. The lesson here is clear. Your voice is powerful in court, but timing, patience, and respect are everything.
Do you want to hire your own attorney? If not, I'm scheduling it for another non-jury trial.
This stuff is crazy. He hasn't reached out to me, Ms. Washington. I live at 685. I have not received no
What
mail.
does that have to do with today? You didn't show up for your hearing.
No.
I'm trying to ask you something very simple. It doesn't get dismissed today. This is a pre-trial. It gets dismissed at a non-jury trial date, which you weren't there. So my question to you is, do you want to hire your own attorney, or do you want me to schedule for another non-jury trial? Because that's where we are.
All right.
Those are two choices. Which one is it?
Just schedule for a non-jury. I am so sick of this, man. All these white people.
Here's the final twist. Even after all the accusations, it turns out the issue isn't neglect or incompetence. The wrong phone numbers and emails are the root of the problem. Buckner's assumptions, combined with his behavior, escalated a solvable communication issue into a courtroom spectacle. This is a reminder that sometimes, in legal battles, clarity and simple verification can prevent unnecessary chaos. And for viewers, notice the subtle irony, accusing your counsel of racism and ineffectiveness, only to find it a simple administrative misstep. Makes this courtroom drama both absurd and cautionary.
Mr. Buckner, please behave appropriately. Please.
Can't work. Look.
So, Your Honor, I think maybe I can say something that might help Mr. Buckner or not. The good news is that I have two different phone numbers for him. Neither of those appear to be the correct number. I have also sent him emails to the email address that apparently he gave to our arraignment attorney. So if that's not the right email address and that's not the right phone numbers, that's the only thing I can think of.
So let's wrap this up. Michigan versus Lawrence Buckner serves as a masterclass in courtroom chaos, miscommunication, and emotional reactions. Buckner's Wi-Fi problems, firing his attorney, and refusal to follow instructions illustrate exactly why professionalism and patience matter. The judge maintained control, calmly explaining procedures, responsibilities, and the limits of court-appointed counsel. Key takeaway: effective communication with your attorney and respect for courtroom rules can make or break a case. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns of courtroom drama.